Hello, everyone that is joining. We'll just wait a few minutes, let some more people tune in, and we'll get started. Okay, welcome. Thanks so much, everyone who is tuning in to this webinar today. Super excited to be joined by our expert speakers, Georgia Mann, Associate at Withers & Rogers, and Mark Cadell, Partner at Withers & Rogers. So before I hand over to Georgia and Mark, I just want to introduce myself. So my name is Stephanie. I'm the Director of Corporate Engagement at ProVeg International. ProVeg is an international food awareness organisation, and we're working to transform the global food system by replacing conventional animal-based products with plant-based and cultivated alternatives. We work with decision makers across the world to help transition the world to a society and an economy that are less dependent on animal agriculture and is more sustainable for humans, animals, and the planet. We currently have 10 offices in different countries throughout Europe, America, Africa, and Asia. Our vision is to create a world where everybody chooses delicious and healthy food that is good for all humans, animals, and our planet. And our mission is to reduce the global consumption of animal-based products 50% by the year 2040. In order to achieve these goals, we work across the entire value chain, which gives us a really unique insight into some of the key challenges, hurdles, opportunities at every stage of the journey to take our product to the market. And so we provide expert advice and really help companies to successfully and effectively harness the power and the profitability of the shift to plant-based eating. We partner with lots of companies from leading brands, retailers, food service, to really support them in their plant-based activities. And you can see some of the brands that we partner with here. And if anybody is interested in learning a bit more about our interventions, I'm really happy to share some more information with you. So please feel free to reach out after this webinar. We recently launched our new food hub, which is the ultimate guide for food industry leaders. It's packed with expert guides designed for busy people, and we've compiled global market data, case studies, professional recommendations, all in one easy to use place to really provide clear, actionable insights around how to harness the plant-based food industry. And please visit the new food hub. We also have a report published on a how-to guide around IP on the new food hub, written by Georgia and Mark and their team. So you can check that out after the webinar, and we'll also be putting a summary of this webinar on the new food hub as well. So without further ado, I'd like to introduce our speakers. So Mark Cadell is a partner and chartered trademark attorney at Withers & Rogers, and Georgia Mann is an associate at Withers & Rogers. And Withers & Rogers is a leading UK and European firm of patent and trademark attorneys, and their capabilities extend across Europe. Mark and Georgia have an active client base in the food and drink market. So there'll be lots of time for Q&A at the end. So do pop your questions in the Q&A section, and then I'll be sure to address them to Mark and Georgia at the end. So as I hand over, we'll kick off with a quick poll. So our poll question today is, have you ever had any experience in dealing with IP, with an IP portfolio? So yes, lots of experience, some experience, or no previous experience. We'll just spend a few seconds letting people answer. Okay, so not many people have plenty of experience, which I guess is why we're all here. Yeah. So yeah, I'll pass over to Mark and Georgia, and hopefully by the end of this webinar, you can tick that yes, I've got plenty of experience box. So yeah, over to you guys.
Thank you, Stephanie. Yeah, absolutely. That's the plan, to try and share some of our knowledge and boost your knowledge of what IP is. So if you give me a second, I'll just pull up our slide deck for today. Hopefully you can all see that now. So thank you for the introduction, Stephanie. I'm a partner in our London office. I'm a trademark attorney, so my particular focus is on brands. Georgia is an associate in our patent team in our life sciences and chemistry group. and her particular focus is around patent protection, innovation, and we're both members of our firm's specialist food and drink group. I lead up that group and have a real passion for brands in the food and drink space. So today, hopefully this will be an enlightening experience for you. We're going to explain what intellectual property is. I know some of the audience have some experience of IP already, but hopefully today will give you more of an insight into what IP is, why it's important, and what your business ought to be doing to protect its IP. So our main focus for today is on what is intellectual property, what does it mean, what are the main types of intellectual property you should be aware of, what you should do to get an IP portfolio and why you'd want to have an IP portfolio, why that's important. And we'll share some of the best practices that we've experienced and also some common mistakes to avoid, and really just give a flavor of why all of this is important. So if you have any questions, as Stephanie mentioned, please add them to the chat and we can answer them at the end. Alternatively, if you have a host of questions that will go beyond the time that we have this morning, then our contact details are at the end of the slide deck, and you can feel free to reach out and ask us anything that you'd like to know more. So what is IP? I guess this is a very high level question that has got lots of sub questions stacked underneath, but really what we're trying to show you today is why IP is important and why the desire of any business to have an IP portfolio should be closely aligned to a general business strategy and certainly not left behind or forgotten about. So what is intellectual property? Really headline answer to that in a sort of theoretical way is a sort of bargain that you make with the government, that you tell the government what your invention might be, what your brand is, and they in return will give you the right, a monopoly right in that particular set of IP. So essentially, it gives you the right to prevent other people from doing things. It's an intangible property right, and like other property rights, it should be seen as an asset of the business, something that you can shout about to investors, something that you can add to a balance sheet. And typically, larger and more successful a business might be, the more and more it's invested in its intellectual property. As I said, it is the right to prevent others from taking advantage of or stealing the creations that you have as a business. It's a piece of property, and like your own home, it needs some TLC, needs some care, something you can buy and sell, something you can license to generate revenue through royalties, for example. So it's a commercial tool that adds a lot of value to a business. But the only way this is all realizable for a business is if you do something about it. There are some intellectual property rights that arise automatically, and we'll come on to explain those in time. But really, this is something that you have to think about at the outset. As a business grows, there needs to be some focus on IP, and there should be some teams internally that look at your IP portfolio, IP strategy, and how this all links into the business strategy. Some examples of what IP is, or some famous examples in the food and drink industry. So there is some patented technology, or there was some patented technology around the way in which corn products were put together. Obviously, corn is a brand, so that's a trademark. We'll come on to explain these terms a little bit later on. There's a patent around the innovation for the process of making the swirl in the middle of a Viennetta product. Impossible, of course, is a brand, trademark registration for that. Also some patented technology in the way in which their products replicate blood and the meat alternative, or the meat comparison to their product. And also some interest in design registration around the way in which the Heinz get up on its packaging is put together. So as you might notice, the product is stacked on its lid rather than on its base. And there's some interesting ways that their design of the packaging or label on the front makes that happen for consumers. So it's quite an interesting way of engaging with consumer base on that front. And the Ritter example here, obviously the trademark and the brand name, and some of their more interesting shape designs for their chocolate products, the square that they tend to use, also perhaps something they have protected by trademark. So brands all around us. Every business has a brand. It's very important that that is, a way in which consumer desire is driven. But if you look under the hood of a business, there might be other IP rights that are in play, particularly patents around some of the creative innovation in this particular space. So we have here our magic IP wheel, the different types of IP that you can get and the things that we are speaking about today. Today, our focus is mainly on registered trademarks, patents, trade secrets, and designs. They all may be very alien concepts to you at present, but hopefully by the end of this morning's session, you'll have a stronger understanding of what each of those things are. And as we said at the outset, I'm a trademark attorney, so my day-to-day life is involved in protecting brands, enforcing brands, and it comes as probably no surprise to you that every business does have a trademark. Every business has a brand, it has a name, it's the way in which you engage with your customer base. And really, it's the way in which you educate customers to buy from you. So the trademark could be seen as what we call, sort of legal terms, the indication of origin. Take a very simple example. I sell flour. Georgia also sells flour. You can buy my flour. It's called Mark's flour. It's organic. You can only buy it in high-end retail establishments. Georgia's product, less good. Very simple manufacturing process. Doesn't taste as good. Certainly not compatible with milk alternatives. Very, very poor quality product. People will buy my product or Georgia's, maybe based on price, but also based on what the brand communicates to them. And I may have spent years investing in advertising campaigns, social media campaigns to educate people to buy from me and not to buy from Georgia. So it's an advertising tool. It's a way of guaranteeing quality. But most importantly, it differentiates what you do from your competitor. It's your communication to the public that this is what you do and why people should buy from you. So that's very important to get that across. On the nuts and bolts of what you can and can't register as a trademark, the absolute test is whether or not a trademark is distinctive. That's the word that's in the law. So you need to be aware that your trademark has to distinguish what you do. It can't just describe exactly what the product is. So good examples would be, thinking back to the previous slide, the word impossible is a known term. It might be quite elusive to the product in that it's achieved something that humanity may have thought was impossible. There's a nod to that, but it doesn't mean anything in terms of the product that's being sold. It doesn't describe a characteristic of it. It doesn't mention that it's a non-meat product. It's very creative and quite an interesting and unique concept. And that is something that is readily registrable as a trademark. So you should think about protecting words. The example we've got is the McPlant logos. We've got the Alpro logo as well. Anything that is part of the brand identity should be considered a trademark and registered. And that includes words, letters, numbers, shapes. We've got the Toblerone shape here, which is very unique. Packaging, Toblerone again. The slogan that your business might use could be possibly registered as a trademark, depending on how unique it is. And as well as that smell, this is a little bit more complicated. It doesn't happen very often, but there are trademark registrations back in the UK from when the law changed, which you probably don't want to know too much about, for tennis balls smelling like newly mown grass. More interesting things, not so every day, but the words or the main brand of the business, any products that are sold within it should be protected as trademarks. Sounds as well, they can be protected as trademark. I suspect that many people in the audience will have heard that before. That is the jingle, as it were, of Intel. They have that registered as a trademark. So if you've got more creative brand assets, those can be protected too. This is a color example for anyone that is the owner of a vehicle driving around the motorway, particularly in the UK. You might guess that this is a trademark owned by BP for the color green. So they have taken steps to protect that particular part of their brand identity for the particular Pantone color that they use. And keeping up to date with all things innovative, you can also register trademarks which move in the format that we have on the screen here. So any digital assets that may be part of your brand identity, those can be protected by trademark registration as well. So what can't be registered? I've touched on this already. things which just describe what you do. I used the example low-fat mayo for low-fat mayonnaise. It just tells you what the product does. Those particular things need to be kept free for everyone to use. There's only a finite number of words in the English language to describe, or any language to describe what a product is. And that's true of generic names as well, like greens for, salad or bags of salad, that sort of thing. And I should note that if a trademark is not distinctive at the very start, if you use it for long enough, convince people that it is a trademark of your business, you can register it later on. But that's more sort of technical, more difficult cases. But as I said, protecting words that are unique and fanciful are the way to go, is the way to go. So what do? You have a business, you have a brand, you have a marketing team that's creating product brands. What next? Well, what you want to avoid is launching that brand after you've invested time, money, emotion in the brand to be told that someone else has got there first, and someone else may have a trademark registration for your brand, and they could write to you and say, you better stop doing this or we're going to sue you in court. That's kind of doomsday stuff. But the way to avoid all this risk mitigation would be to conduct what we call trademark clearance search. So you find out in the countries of interest to you, and these rights are territorial, so it could be UK, European, USA, whatever it might be. Search to make sure you're not going to infringe someone else's trademark when your product is launched. Otherwise, you may have to rebrand, take all your products from the shelves that they're presently appearing on, and start again. So do that ASAP once you've created the brand, before you even spent any money putting packaging together. Do it as early as possible to avoid disappointment later in time. Why do you register a trademark? I think I touched upon this earlier on. It's very important to have the assets of your business under your control. They are essential, particularly from a brand perspective. You don't want to have copycat situation or anyone counterfeiting your products or getting too close to how your brand looks. So trademark registration is the way to allow you to prevent that. You can stop people using an identical trademark for what you do, or even similar trademarks for what you do. Again, early action and proactivity is key, and registering the key brands that are in your portfolio. That could be your brand name, logo that you use, any strap lines that you use. Taking account of all of those things early on is going to save you some difficult conversations in the future. I won't elaborate too much on what the trademark registration process is, but essentially you fill an application, tell the government what the trademark is, what products you want to use or services you want to use it for, and they check if it's legally suitable. They also give third parties a chance to challenge the trademark application. If they have other trademark rights that they could allege to be too close to yours, they might try and stop your trademark becoming registered. Process is quite quick. In the UK, probably 4 months. In the European Union, it'd be 5 months. Differs around the world, but not much quicker than what patent protection takes to get through to grant. And trademarks can last forever. They're not necessarily time barred. A couple of caveats to that. They exist in 10-year blocks. You have to pay a renewal fee every 10 years to keep the trademark alive. And also there is a use it or lose it principle, which typically around the world is either 5 or 3 years, where if you stop using the trademark for a period of 5 years, someone could come along and cancel the trademark and start using it themselves, in theory. So it's important to forecast, and this is why I mentioned your business plan. If you know you're going to be selling into particular territories, particular countries, it's a very good idea to try and ensure you're not going to infringe any other trademarks there and register your trademark in those territories before you ship products anywhere. And also have the foresight to understand how the business might grow over time. So you might presently offer plant-based milk product. You may 6 months down the line have ideas of moving into, say, alternative butters or yogurt space. Then making sure you have all of those particular product categories covered at the outset means you don't have to revisit your trademark portfolio and file a new trademark application. You can't add to what you already have. So keep an eye on where you're protected, analysing any gaps that you might have. Again, having the foresight to align your territorial expansion, your portfolio with the business is very good. Keep an eye out for anyone else filing trademark applications that might compete with yours. There's a way in which you can put a service in place to look for that for you. And finally, one of the things that we often get asked is, what can we do with these little symbols we see a lot, the trademark symbol and the registered trademark symbol. So the little TM symbol, is you telling people that you treat your brand as a trademark. It means trademark, hence TM. But you can use that for anything at any time. It doesn't have to be on registered trademarks. But the R in a circle is the gold standard, where you use that particular symbol alongside trademarks that are registered. And sometimes a stylistic decision, but essentially what you're doing by using those symbols is telling people that essentially keep off the grass type warning, that you have a brand that is registered, or you think it is a brand that you should be able to enforce, and they shouldn't use it. So it's important to communicate the trademark message externally as well, to avoid people just thinking that they can use your trademark without any permission. I'm going to hand you over to Georgia now to talk about patents. Thank you, Georgia.
Thanks. So what is a patent? So a patent protects how something works. It's a legal right. It protects technical features, products and processes, for example. As Mark said, IP rights are negative rights. A patent is a negative right. It's the right to stop others from using your protected invention. So it's a monopoly right. And it's granted in exchange for publishing your idea. You publish your invention. In exchange for this government monopoly right, you have to disclose your idea. It can last up to 20 years, so different trademarks, and you subject to those payments, you can have protection for up to 20 years. And as with trademarks, it's a territorial right, so you do have to seek protection in the countries where you desire patent protection. So try and move the slide. This worked before. Might take it. Oh, it's done it. Right, there we go. So what can we protect? So if we're thinking about the food industry, we can protect products, food products, drink formulations, we can protect equipment, whether it's food dispensing products, methods of making a particular food type, machinery. So here's just a few examples, extending shelf life, for example. Other things we've come across, instant noodle formulations that don't clump when you rehydrate them, novel crystal structures of ice lollies that can retain flavor better. So there's a lot of different things you can protect. You can protect improvements. Let's say that there's a known method of doing something. You find a way of making it faster, making it more sustainable. You can protect that improvement. Oh, sorry, it's going to be a bit crazy. So in order to be eligible for patent protection, you have to meet a few requirements. So you have to be new. So by that, your invention can't have been disclosed by you or anyone else anywhere in the world, whether that's online, whether that's in the form of another patent application that's published. And this is really important for self-disclosure. So, if you're going to a conference or you're publishing something and you've not actually put your protection in place, it's really important to understand that point, that you have to be new to be considered eligible. Inventive. So by that, we mean that it can't be considered obvious in view of what exists to someone that works in that particular field. So what you're looking for is an unexpected technical advantage. You're looking for a surprising solution to a problem. Industrial applicability is quite a low bar. It basically just has to be capable of industrial application. This is often an easy requirement to meet. Not excluded. So by this, not everything is eligible for patent protection. This can vary by jurisdiction. So in the UK, for example, you can't get patent protection for a business method. So that would be considered excluded subject matter. Sufficiently described, as I mentioned, you're publishing your invention in exchange for your rights. So you have to describe at least one way of implementing the invention, such that upon expiration of your patent, a third party can independently work that invention. You're enhancing the sum of knowledge, effectively. How do we get them? So as Mark flagged earlier, it's a simple schematic of the process. You start off with filing, and then you go into your search stage. And this is where the Patent Office will identify all published documents that would be considered relevant to your invention. And that will give you an idea of how new and how inventive your patent application is. If it's all looking good and you think, yeah, I'm new and I'm inventive, I think I can argue this, you'll likely proceed to examination. That is where there's some arguing of your patentability case with the Patent Office. If the examiner agrees, you'll get a granted right. So the granted patent right is important because you cannot enforce a patent until it's granted. So if you do need to enforce it against someone, you have to wait till grant. You cannot enforce a pending application. Timescales, I put the UK and Europe here as an example, but it varies by jurisdiction. So for example, it can take up to 10 years in some countries like Brazil. You can accelerate patent applications through to grants. There are different mechanisms around by jurisdiction, but one thing to factor in is that if you are accelerating, you're condensing all the costs into a shorter time frame, so there's financial considerations to that. And you have to pay renewal fees to maintain a granted patent in force. Some laws require that you pay fees for pending applications as well. So they're just some financial considerations to keep into account. Patent searches, so similarly to what Mark said, there's a similar mechanism for patents. There's different searches you can do. One of the most common searches that we would come across is search for third-party existing rights. You don't want to invest a lot of money in commercial activities that are going to encroach upon someone else's patent right. And often, you know, you want to mitigate that risk. Your company, your investors will want that reassurance. So that is one way you can use a patent search. You might want to, you know, let's say it's a crowded market, you're not really sure how novel and inventive you are. You might want to search and see what's out there and just see whether you want to commit to filing a patent application, whether you think you can get a good scope of protection. You might use a patent search to look for areas in the market that you might want to focus your research and development on. There's a lot of technical information out there. If it's a particularly crowded space, you could look at the landscape, look at the gaps. Is there anything I can commercialize in those gaps? Maybe I want to focus some of my R&D efforts in that less crowded sector. So patent searching can be a useful tool. It is expensive, so that is a financial consideration to these. You know, if you know your market really well, you might not want to invest that money in a search. You might instead want to invest it in preparing and filing an application. So just some things to consider. Oh, there we go. Just some benefits now. So a patent reduces the likelihood of your competitors from making and selling your invention. Not only have you got a legal remedy to stop them if they do, patents act as a deterrent. If a company sees you've got patent protection in place, it's likely to act as a deterrent for them to start going after that product space too. And if you're preventing your competitors by undercutting you, you know, in terms of copying, it's likely going to have a good impact on your profit margin. Marketing literature, that can be really good to attract customers. You know, I, for one, am a bit of a sucker for this. If I see something's patented technology, more so now since joining the profession, it does actually attract me to that product because there's an element of credibility that's given to it. Patent box tax relief, it's available in some countries like the UK. You can get a reduced corporation tax on profits from your patented products or your patented processes, for example. Income. It's as Mark said, they're assets. You can license them, you can sell them, you know, you can bring in revenue. A client of ours who manufactured ice cream machines, he actually got a patent for the core tech and he exploited that with licensing agreements across the supply chain. He had a license for the person making the machine or the company, a license for people selling, a license for the use. He also had a patent for the cartridge that went in the machine, and so he could license the manufacture and sale of that independent of the machine itself. So they can be really useful tools for generating income. And you can use them to protect things that you can't keep as a trade secret, which I will talk about a bit later. But first, I'm going to ping back to Mark to talk about design.
Okay, thank you, Georgia. Yeah, we mentioned before the IP wheel, the magic wheel, different IP rights. We thought it'd be worthwhile mentioning just briefly what designs are, different to trademarks, different to patents. Design, which can be, again, something you apply to register, will protect the appearance of a product. So this could be actually the logo that the business uses, or more typically, a particular shape of a product. Or packaging. So if something is unique, slightly different to what's been done before, it can be protected as a registered design. That's what we call the way in which shapes are protected as design. So you could often have a trademark and design for the same thing, but really this is an additional layer of protection and is a very helpful way to prevent against copycat products, particularly in the packaging space. There's often some interesting cases. It seems in the UK at the minute, there's been a few of these recently where discount retailers have been copycatting leading brands. And one of the things that's important to bear in mind is that the way in which you can make that stop is by having a robust portfolio in place. And sometimes designs are overlooked in that. So you can have a registered design. Again, you apply to whichever jurisdiction you want the design in, and you'll be granted the monopoly right in the last 25 years. And the other thing which is on the slide is copyright, which I guess you need to know is free, automatic, something you don't have to pay for a change. And this is also true for unregistered designs, which can come into being if you have a design which is unusual, unique, and you get a limited period of time to prevent someone from copying exactly what it is you've got. And copyright does what it says in the tin. It gives you the right to stop someone copying your products. That could be artwork that's on your packaging, could be something like the content of your website, any articles that you put together, there'll be copyright in the content. So these are other things just to bear in mind. And the beauty of a registered design is that you don't actually have to show that someone copied it, bit by bit. As long as there is a similar overall impression, you can take action against infringers in that space. Excuse me. Yeah, territorial rights, it's a common theme. Pretty short process for registered designs, in the UK and the EU, weeks, days sometimes. So if you want to get something registered to enhance your portfolio, it can be quite helpful just to have some design registrations in place. For some foodstuffs, they have to just be a particular shape because it's dictated by their function. So this could be more for unusual food shapes or unusual packaging shapes. We've handled some cases for particular ways of cutting things, and the shape is unusual, but it's quite hard to get trademark registrations for those. So we often fall back on design if we can, if we know they are a little bit unusual. There's no examination of designs in the same way as trademarks and patents, so they can be quite easy to obtain. And an additional thing to bear in mind, really, limited lifespan like patents. So registered design lasts up to 25 years. And for unregistered designs, at least in the UK and EU, 10 years in the UK and 3 in the EU. So just an additional thing to bear in mind, because you could potentially be creating IP without knowing it, particularly around copyright. So if there's someone that is, essentially copying exactly what your product looks like, looking beyond trademarks, and patents won't really help you in that situation. So, but looking beyond trademarks, designs, and copyright can be a nice sort of team of IP rights to tackle infringers that way. We're going to talk about trade secrets now, and I'll hand you back over to Georgia.
So I'm aware of time, so I'll try, this in itself could be a talk, so I'll try and focus on the key elements. So a trade secret, the clue is in the name. It is an intellectual property right that isn't known to the public. You can use it to protect a wide array of different things. It's not limited to technical information. And it's the right to prevent that information that's lawfully within your control, because you've got that trade secret, from being disclosed, acquired, or used by anybody else without your consent. And similarly to trademarks, trade secrets can be protected indefinitely as well. So this is where it's gonna, there we go. Just some famous examples. I know not all of them are plant-based friendly, but these are some classic examples of trade secrets. Coca-Cola is arguably the most famous in the food and drink industry, I would say. They made the clever decision of branding their recipe as a trade secret instead of a patent, and given the longevity of the product, that was a really good decision. As I said, it's not limited to technical information. This is just an example of things. You could have customer, prospect lists, financial projections. There's lots of different things that can be eligible for trade secret protection. Oh, let's not sidestep the law. So EU, the UK, and the US are quite well aligned. So, for example, in the UK, we've got a legal test. There's 3 requirements for something to be a trade secret. First, it has to be a secret. What do we mean? Not generally known, essentially, not readily accessible. So, for example, something online would never be considered a secret. It has to have commercial value because it's a secret. So it doesn't matter that the information itself is valuable. It has to give you an economic benefit from being kept secret. And you have to show that you're taking reasonable steps to keep it a secret. You can see below the US, they use the words reasonable effort. So what does that mean? It's a bit of a gray area. It's dependent on the nature and size of your company. If you're a smaller company, you're likely not going to have to take as many measures as a huge corporation that has multiple different subsidiaries, for example. Things like non-disclosure agreements, contractual clauses, security, things like that. Just to show that it's people can't access that information unless they're unlawful. So when you're innovating, there's a decision often in this world. Do I patent? Do I trade secret? What do I do? Like a lot of things, weigh up the pros and cons. Trade secrets don't have to be new and inventive. If you don't think you're going to meet that patentability hurdle, you might want to keep it as a trade secret. You can have things that aren't eligible for patent protection. Trade secrets can evolve over time. Trade secrets also can potentially last forever. It might not be that important in a market, for example, where it's fast evolving, and 20 years actually is, a large amount of time. But in some instances, that time frame can be quite limiting. There are disadvantages. It is perfectly okay for a third party to come up with your trade secret completely independently. They can still use that. They can also take your product and reverse engineer it, and they can identify the trade secret that way. So if you've got something that's reverse engineerable, it's unlikely that trade secrets are going to be that good for that particular concept. You're probably better getting a patent, because with a patent, it doesn't matter if someone comes up with it independently. If you've got there first and you've got your protection, you can stop them. And then finally, quite a big one, once the secret's out, it's out, you've lost protection. So that's an important consideration. That includes accidental disclosure. So just a quick remember, so you don't have to register it. There are some legal requirements you have to consider. It only protects you against dishonest acquisition, disclosure, or use. And so if you are going to be using trade secrets, and they can be a valuable tool, particularly in the food and drink industry, to underpin some high value companies, it's important that you develop and you maintain a trade secret program, that you monitor, you document, you continually review, and you have this in place, because not only is that good business to prevent loss, but also it's a legal requirement to show you've taken those reasonable steps. So that's just a really important take-home message. So a few more slides, and then we can move on to the questions. So just wanted to show you how it all fits together, really. So let's say you've got a really cool product. There's a couple of problems you've solved. You might file a couple of patents for that. You've got your prototype. It doesn't look very nice. So you throw it to your design team. They make it look really cool. You might have some design rights coming out of that. What are you going to call the product? What's the name of your company? What's your logo going to be? What's the branding? That is where trademarks are really powerful. And so you can see that you're inherently creating IP when you create a product, for example. And how you're going to exploit it, you're going to license it, you're going to sell it. So it's just a nice way of seeing how all these rights fit together. How can it help? So as Stephanie mentioned, we have done an article which goes into a lot more detail on this. So I'm just going to whiz through. But a key point that we've mentioned throughout, intellectual property brings in revenue. It attracts investment from independent investors or funding. There's often, you can sell, you can license. That's one important thing to acknowledge. You can get tax relief, which is obviously good for the bank. You can attract customers. If you've got really powerful branding, if you've got really attractive designs, if you've got, innovative patented technology, that can draw in customers. And, IP rights, they're a negative right. You can stop people encroaching on your rights. You can defend and protect your market share. So they can be really powerful tools for a business. How do I get started? It's a bit of a minefield. So just a couple of tips. As I said, there's more information and links on the article, so please do use that. Education, educate yourself, look for funding. As we've said, these, protecting your rights, there's a cost implication to that. Funding can help, especially when you're a startup, you're at the beginning of your journey. It's a difficult economic climate. It's really important to, thanks for that, guys, for putting that up. It's really important to incorporate IP into your budget, to have it tied in with your business plan. From a patent and trade secret point of view, keeping your ideas confidential until you've established your protection is really important. Obviously, if it's a trade secret, keep it confidential for hopefully forever. Check you're free to operate. As we said, with searching and things like that, check that your commercial activities aren't going to encroach on someone else's existing rights. And finally, it's a complicated world of IP law. Seek expert advice where you need it. We're here to help. IP, patent attorneys, trademark attorneys are here to help you with your business. So don't be afraid to ask for help. So thanks everybody for listening. I hope you found it useful. I'm just going to put this slide up for the recording purpose so you can see our contact information, and I will pass you over to Stephanie.
Great, thank you so much both. Super interesting and so much detail as well. I've learned a lot. So we have a couple questions already, but if you haven't asked your question, there's still time. So put it in the Q&A or the chat. But our first question is, if a business company and a university developing a technology together, can they agree that the patent later would be sold or licensed only with both sides in agreement? Is such a practice common?
So obviously, yeah, it is common for universities to innovate in partnership with companies. But one thing that is often established at the outset is who's going to own the IP that comes out of that innovation. So usually there's an agreement between the parties. For example, the company that's funding the research will say, okay, any innovation that comes out of this project, we want to retain the ownership of that IP. It might be that you have a joint ownership situation, but often people tend to avoid joint ownership because there can be issues around, you need permission from certain parties to make changes and things like that. So ownership is something to definitely understand at the outset before you seek protection. You need to know that you have the right to file and to protect that invention, basically. I hope that answers your question.
Great, thank you so much. So another question, if you were to patent a process, are you able to use the process before the patent application? If not, once the application is first put in, are you then able to start using the process?
So as I said, you have to be new. So if you're using your process, you just have to make sure that it's being used in confidence and it can't be considered as an enabling disclosure of your process, because otherwise that can be used against you in the patent process in terms of that new hurdle that you have to hit. But once you filed your patent, you can disclose your process, you know, if that's something that you want to do. So yeah, it all depends really. It's best to keep it confidential or under non-disclosure agreements. If you're, you know, if someone's using your process and testing it for you, for example, you want to have that agreement in place if you've not filed any protection for it.
Great, thank you. Someone is asking if you deal with content in the entertainment industry.
We would deal with I guess the entertainment industry is quite broad, but you know, the names of television shows, bands, films, or maybe those are all assets that can be protected by trademarks. So we do work in the space for that reason. We don't really advise on the protection of what will be considered to be the entertainment angle to that. So if you are, let's use an example, launching a game show, the format of that, we wouldn't really advise around the ins and outs of kind of how that works and if it's copied and trying to stop that. So we can do some, but probably not everything in the entertainment industry. But I guess that question is sufficiently vague that I don't know exactly what we'd be asked to do, but we can help in some instances, and probably less so. Well, maybe there might be some interest in patenting questions in that space, but it depends on what's needed. For example, contracts or licenses with artists in the space, we probably wouldn't get involved in that. That's probably more a thing for a commercial lawyer to deal with. But anything IP related, yes.
Right. In the case of two companies collaborating on an innovation and pursuing a joint venture, could the joint venture become the owner of the IP?
Yeah, so you sometimes see that there's different companies or different individuals, and often you can form your own company, individual limited company, and you can have all the IP directed into there to streamline things. So yeah, that does happen. Or you can have a contractual agreement in place where one company, you know, there's an agreement agreed between the two in terms of the IP ownership.
Thank you. Okay, we maybe have time for like one or two more questions. Somebody is interested in resale royalties. Would you suggest I work with galleries directly or join a law firm?
Oh,
That's probably going to be a question for
solicitor maybe?
licensing arrangement, which the royalty is generated from. So essentially you'd be licensing someone to use your IP, generating revenue from that. And there is we are quite a niche practice in the sense that we, protect and enforce IP. There's another niche practice around licensing and putting those deals in place. So speaking to someone in that space, and we can recommend someone if that's needed, is the way to go for that. I would say it's quite important to get those contracts set out properly at the outset. Like Georgia was saying about ownership, these are the things that often seem quite easy but can be quite complicated and harm you later in time. So it's good to get early advice.
And there can be overlap with some of the grey areas. So as Mark said, if you're not sure, then we know people and other attorneys, patent attorneys, trademark attorneys will likely also have contacts as well.
Great, thank you. In the interest of time, we'll do one more. So the last question, do you suggest any particular tools to conduct IP research?
On the trademark side of things, there are quite a number of different open databases where you can essentially search for registered brands. And you could almost all countries, well, not all, but a lot of countries have accessible databases. So if you wanted to search, for example, any trademarks that are registered in the UK, if you just conduct an easy search online for UK trademark search, it'll probably direct you to the website, the government website, and it's very user-friendly. You can play around with it and try and find out what's out there already. So that's, again, a rough and ready way of doing some trademark research. I'm not sure it's as easy on the patent side, Georgia, is it?
I mean, similar. There's things like Fastnet, Google Patents. You can do keyword searches, and it's similar. It's rough and ready. It's not as good as a formal instructed search where these people are kind of they do things by classification. You can do rough keyword searches to identify some patent applications or patents that exist. So yeah, it's Fastnet, Google Patents. You can also look on the European Patent Register for that's European specific, and national patent registers through keyword searching, I would say. But yeah, there are tools as well in terms of there's things like PatBase where I think you need to have a subscription. There are subscription products as well that you can kind of look for data and analytics and things in and around certain sectors. But yeah, that's what I would say for patents.
Amazing. Thank you so much. There's still questions coming in. So if you haven't had your question answered, you can reach out to Georgia and Mark afterwards, and their emails are, maybe go back a slide, available. So write them down now. And I'm sure they'd be happy to answer any questions. So thank you so much both. I think really interesting session. I've learned so much, so I hope everybody else agrees. And yeah, check out the article on the New Food Hub for some more details. Feel free to reach out to both of our panelists. And thank you so much to both of you. And thank you so much to everyone for joining.
Oh, thank you so much for having us.
Thank you for having us. Thank you everyone for joining. Hope you found it useful.
Have a lovely rest of your day, everyone. Thank you.
Thank you. Bye, everyone.
Thanks. Goodbye.